think I relate to any of my characters. I've played a crack addict from Boston. I've played an Upper East Side princess.
That day has turned into something far more significant than just another entry on the calendar because it represents a milestone in the Blake Lively legal saga. The lawsuit that has dominated headlines, exhausted resources, and revealed to the public a portrait of desperation and arrogance that is becoming increasingly difficult for her team to hide. We are now 5 days removed from the substantial production of documents deadline, the crucial date when all third-party subpoenas had to be complied with, and what this means in simple terms is that Blake Lively can no longer scatter subpoenas across the country like confetti unless she can persuade the court that she has good cause to do so and secure judicial approval, because every subpoena she had issued had to have been answered by August 15th, and from that point forward her only recourse is to file motions to compel within the limited window, specifically until this coming Friday, asking the court to order compliance from those who may have ignored her demands. In other words, the era of unrestricted subpoenaing, of dragging random third parties into this mess just to create the illusion of progress or intimidation, is now over, and that deadline changes the dynamic completely because without those endless subpoenas Blake loses one of her most aggressive tools of harassment in discovery. Now if you have been following this case closely you will know that Brian Friedman's firm, through his associate Kevin Fritz, filed a notice with the court making it crystal clear that despite Blake issuing subpoenas to an astonishing 107 content creators, not one of them, not a single YouTuber, TikToker, blogger, or commentator turned over anything that remotely resembled evidence that Friedman orchestrated a retaliation campaign against her, let alone paid people to create videos targeting her, and to the best of their knowledge all that was received was either irrelevant or exculpatory, leaving Blake with a pile of nothing. She wasted not only their time but also their money, and in doing so she displayed the reckless arrogance of someone who believed that intimidation and volume could substitute for substance. And this is where the irony comes into play, because back in February, March, June, and even July, her team was proudly issuing statements through friendly media outlets proclaiming that they had overwhelming evidence, that they could not wait to bring the case to trial, that the smear campaign and harassment were proven beyond question. But now in late August, after the dust of discovery has settled, the public record tells a completely different story. They have nothing, not even a thread to hold on to. This contradiction becomes more glaring when you recall that early on Blake's PR framing painted the lawsuit as fundamentally about sexual harassment, a narrative meant to evoke sympathy and seriousness, but curiously that refrain has all but disappeared in recent months, and when you examine the evidence she herself submitted into the docket, it is almost laughable. The only complaint made to Sony HR that she could produce involved a text where Justin Baldoni allegedly remarked that an outfit worn by Lily was sexy, a comment that, according to the context, was in line with Blake's own directive that Lily's look was supposed to be sexy for the scene. Nevertheless, Blake and Jenny attempted to weaponize that passing remark as harassment. If that is the strongest proof she has after months of litigation and hundreds of subpoenas, then the foundation of her claims is not just weak, it is non-existent. And yet this shouldn't be a surprise to anyone who has paid attention to Blake's own words over the years, because in interview after interview she has openly admitted that she enjoys lying to journalists precisely because they cannot fact-check her in real time. She laughs about how she spins stories, fabricates anecdotes, and manipulates narratives as a kind of game, and she often brags about acting out of revenge or spite for petty reasons, such as baking intentionally ugly cookies just to punish Ryan Reynolds for traveling without her. When someone tells you who they are, believe them, and Blake has been telling the world for years that manipulation and deception are her weapons of choice. So while the subpoena campaign failed to unearth a single shred of evidence against Friedman or Baldoni, do not expect that to deter her from pressing forward with a case she cannot possibly win, because the driving force is not truth but ego and the inability to concede defeat. Adding to her humiliation is the intervention of Perez Hilton, who submitted a note to the judge drawing attention to the abusive state of the docket itself, highlighting how Blake's endless filings, personal attacks and reckless disclosures were making the proceedings a circus and an embarrassment in the eyes of the public. The court took notice, and with the production deadlines now passed and her power to subpoena curtailed, Blake's activity on the docket has gone eerily silent. There have been no new filings from her team since last Friday, a sharp contrast from the near-daily barrage she had unleashed for months. This silence is not accidental, It is the result of judicial orders that forced her into a sobering reality, including the humiliating directive that she alone, not her opponents, not the court, had to go back through the docket and redact personal information she had improperly exposed. An astonishing twist given that she herself fought for a protective order to safeguard private details, only to be the one who violated those principles. That scolding, make no mistake, was real, and it stripped her of the ability to pretend she was operating from a position of moral authority. Compounding the seriousness of this moment is the disturbing context of real-world consequences. The court has been notified multiple times of an incident where one of Blake's fans allegedly attempted to set a fire and even kidnap Steve Sadowitz's daughter. A chilling reminder that weaponizing litigation as PR can spill into dangerous fanaticism. Yet even against that backdrop, Blake's team has grown quiet this week, limiting themselves only to responses regarding Perez Hilton and Andy Signore's motions to quash subpoenas in Florida and Nevada, while leaving the main docket silent. This silence is deafening because it signals the inevitable stage in any lawsuit when discovery is over and the plaintiff must finally confront the reality of their case. After 8 months of litigation, hundreds of filings, and enormous expense, Blake has failed to prove that she was smeared, harassed, or retaliated against in any way that would hold up in court. Without evidence, there is no case, and though she may try to push forward, the likelihood of success is zero. What makes this fall from arrogance so stark is the tone of her recent letters to the judge, where once they brimmed with confidence and proclamations of overwhelming proof, they now read more like desperate complaints, crying that others' noncompliance is the only reason she cannot connect the dots, as if the inability to trace the untraceable were someone else's fault. The shift is palpable and deeply damaging to her credibility. Meanwhile, Baldoni's side, along with Wayfarer, has responded to Blake's filings with deliberate restraint, heeding the judge's order against abusive rhetoric, avoiding name-calling and presenting measured arguments. That contrast, Blake's shrill desperation versus Baldoni's calm compliance, underscores for the court who is behaving like a serious litigant and who is abusing the system. For those who doubt the gravity, consider the judge's latest warning. The court has made clear that if Blake or her allies continue their antics, they risk contempt of court. This is not a symbolic threat. Contempt carries real penalties, from fines to potential case-crippling sanctions, and in the context of an already floundering lawsuit, it could be the final nail in the coffin. So while some critics dismissed headlines suggesting Blake faced contempt as clickbait, the legal reality is the opposite. When a judge issues an order demanding appropriate conduct and threatens contempt for violations, that is a very real sword hanging over her head. The bigger picture is now unavoidable. Blake lively entered this lawsuit trumpeting accusations of harassment, retaliation, and smear campaigns, claiming mountains of evidence and righteous intent. But 8 months later she stands exposed, empty-handed, reprimanded by the court, stripped of subpoena power, her credibility shredded by her own contradictions, and her legal strategy reduced to silence because she has nothing left to say that can withstand scrutiny. The arrogance that carried her here has evaporated, replaced by the sobering recognition that in the absence of evidence, all she has left are theatrics. And theatrics do not win in a court of law. The Blake Lively lawsuit had reached a critical and almost surreal stage where every move on the docket, every word written in filings, and every procedural deadline carried a weight far beyond dry legal mechanics, because they revealed the unraveling of a strategy that was built on intimidation and bravado rather than on facts or evidence. And nowhere is this more clear than in the events surrounding contempt, Isabella Ferrer, and the sobering realization that discovery deadlines have stripped Blake of the weapons she used most aggressively. The public needs to understand that when we talk about contempt in the context of civil litigation, we are not talking about a vague warning or a symbolic slap on the wrist. We are talking about a concrete legal process where one party files a motion for contempt, lays out how the other party violated a direct court order, and asks the judge to impose sanctions that can include monetary fines, restrictions on filings, or even striking parts of a case. And in this matter, any single one of the defendants or even third parties harassed by Blake's tactics could at any time file such a motion and put her in the position of having to defend conduct that the court has already warned her is unacceptable. This means that Blake can no longer rely on her old playbook of flooding the docket with vitriol, personal attacks, or irrelevant filings aimed at poisoning public opinion, because those filings are now themselves a liability that could draw sanctions, a reality underlined by the second notice filed by Wayfarer in response to Blake's side just days ago, which explicitly told the court that Blake's attorney violated the August 8th order by filing an opposition letter that was nothing more than an inappropriate attack on Baldoni and his counsel. The language used was unmistakable, in violation, a phrase repeated with emphasis to ensure the judge would not overlook it, and that phrase alone carries serious implications because once a court order exists and an attorney is accused of violating it, the judge does not treat that lightly, and the defense was essentially signaling, "Judge, this is contemptuous behavior, do something about it." The motion made clear that Blake's side had inserted irrelevant personal attacks in a response to a simple procedural matter. The motion to serve Isabella Ferrer by alternative means, something that should have been routine but was twisted into another vehicle for character assassination. What Wayfarer did here was smart. They did not just argue service mechanics, they turned the spotlight on Blake's misuse of the docket, reminding the judge that not only was this irrelevant, but it directly violated the court's warning, thus putting Blake's attorneys at risk of sanctions themselves. And here is where the Ferrer issue becomes a microcosm of the entire lawsuit, because Isabella Ferrer's involvement is riddled with contradictions and manipulation. To understand the irony, one must recall that it was Blake herself who first identified Isabella as a witness in her disclosures, even going so far as to provide an address for her. In other words, Blake was the one who put Isabella on the map of this litigation, not Wayfarer, not Baldoni, not Friedman. Yet when Wayfarer later attempted to subpoena Isabella for documents that were critical to their defense, documents they suspected she possessed but had not been turned over through Blake's subpoena, suddenly Isabella's attorney Mr. Mitchellman resisted. This is despite the fact that when Blake originally subpoenaed Isabella, Mitchellman had accepted service on her behalf without objection. The inconsistency is glaring. When Blake calls, the subpoena is fine. When Baldoni's side calls, suddenly it's harassment. Wayfarer documented their efforts carefully. In July they subpoenaed Isabella. Twice they reached out to Mitchellman with the professional courtesy of asking him to accept service. Twice they were ignored, forcing them to attempt personal service. Rather than simply accept and produce documents, Isabella's counsel filed an opposition. A lengthy opposition that spent more time smearing Baldoni and his team than actually explaining why service was being resisted. This opposition accused Baldoni of harassing Isabella, of dragging her deeper into litigation against her will, of abusing the process. Yet all of this ignored the undeniable fact that Isabella was only in this case because Blake herself named her, subpoenaed her, and brought her into the spotlight. Wayfarer's response dismantled this contradiction point by point. It was not they who first subpoenaed her, it was Blake. It was not they who gave her address to the court, it was Blake. And it was not they who accepted service without objection, it was her own attorney when the subpoena came from Blake. For Isabella and her lawyer to now cry harassment when Baldoni sought documents was, in Wayfarer's words, nothing more than creating issues where none existed, issues that ironically increased the attorney's fees they claimed to be burdened by. And then came the most important part of Wayfarer's filing, the offer to stipulate. Baldoni and Wayfarer essentially waved a white flag of reason, saying in effect, if Isabella does not want to be a part of this, that's fine. We will withdraw our subpoena. We will stipulate that none of her communications will be used by anyone, we will exclude her as a witness. Let her go, let her be free of this litigation. It was an elegant move because it placed the burden back on Blake. If Blake wants Isabella in, then it is Blake who is forcing her into the litigation against her will, not Baldoni. If Blake refuses to stipulate, then it becomes obvious to the judge that it is Blake, not Baldoni, who is harassing Isabella. This is strategic brilliance. It forces Blake into a corner where either she looks like the manipulator dragging an unwilling young woman into court, or she gives up one of her supposed witnesses, and weakens her already crumbling case. And what makes this even more damning for Blake is Isabella's own prior words, because when she wrapped her work on Baldoni's film she reportedly expressed gratitude, saying she had an incredible experience, praising him for creating a safe and comfortable environment, hardly the words of someone traumatized or mistreated. Only later, after getting close to Blake, did she begin to parrot accusations of harassment, but the timing and circumstances raise obvious doubts. Is this really her experience or is it Blake's influence shaping her narrative? Wayfarer suspects the latter, and that is why they want her communications, texts and messages between Isabella and Blake, because those may reveal manipulation, coaching, or even dishonesty. Isabella's resistance to turning over those messages only fuels suspicion that they do not support Blake's claims. So in this battle over Isabella, we see the larger war in miniature. Blake weaponizes people as witnesses, but when those people are asked to provide balanced discovery, suddenly it is harassment. Blake cries foul when Wayfarer insists on equal treatment, but it was her own choices that put these individuals in the firing line. The court, confronted with this, cannot ignore the pattern, and Wayfarer is making sure every filing highlights it. Every motion reminds the judge of the August 8th order. Every violation is documented so that when the moment comes, they can move for contempt and point to a trail of disobedience. This explains Blake's sudden silence. 4 months she flooded the docket, filing something almost every day, turning the lawsuit into a PR campaign. But once the judge's orders landed, forcing her to redact improperly disclosed information, warning her against abusive filings, cutting off her ability to issue new subpoenas without court approval, her arsenal evaporated. Add to that Wayfarer's new strategy of calmly documenting every violation and signaling contempt motions, and Blake now faces a landscape where every filing risks sanctions. It is no wonder her team has gone quiet since last Friday. Think about where this leaves her. She has burned months of litigation insisting she has overwhelming evidence, yet after 107 subpoenas she produced none. She framed her case as sexual harassment, yet the only HR complaint she filed was about Baldoni complimenting an outfit Blake herself wanted to be sexy. She fought for a protective order to guard privacy, yet she was the one who repeatedly exposed private information and had to be ordered to redact it. She claimed to be the victim of smear campaigns, yet she has been caught lying in interviews, admitting to manipulation, laughing about how she deceives journalists. And now, with Isabella Ferrer, she has painted herself into another corner, either forcing an unwilling witness into litigation or admitting that her claims about other women on set backing her up were baseless. Meanwhile, Baldoni and Wayfarer are playing the long game, filing responses that are professional, measured, respectful of the court's orders, careful not to give Blake any ammunition for further theatrics. They are signaling to the judge that they are the adults in the room, that they will not be baited into abusive exchanges, and that if Blake persists, they will be ready with motions for contempt. The contrast is stark. Blake's silence now looks less like strategy and more like paralysis in the face of a losing hand. This is why I said last week that the rulings were not good for Blake, because each order that restrains her behavior, each deadline that passes without evidence, each opportunity for her to prove her claims that instead exposes her emptiness, shifts momentum to Wayfarer. Even when observers complain about Judge Lamone's rulings, what cannot be denied is that Wayfarer has made it clear. They will not lay down, they will not be intimidated, and they will not allow Blake to control the narrative unchecked. The legal system is finally imposing boundaries on her tactics, and those boundaries are suffocating her case. So the story now is not one of Blake triumphing with overwhelming evidence, but of Blake cornered, stripped of her subpoena power, exposed as manipulative, facing the real possibility of contempt sanctions, and left to decide whether to keep dragging unwilling people like Isabella deeper into the mud or to retreat and watch her case collapse. It is a sobering moment, the turning point in litigation where fantasy meets reality, and reality is not on Blake's side.